Okay, I think we should kick off the session. Welcome. Thank you very much for attending. You're looking at a webinar this morning, Rethinking the Client Journey. My name is Alan Larkin. I'm the Head of Innovation at Family Law Lab. I think I should just take a second to thank Resolution for assisting in the co-hosting of the webinar this morning. So let's start off on this. And the main thing to tell you about, of course, is that if you're here for a think piece, I guess a speculation on what may happen in the future, you're probably in the wrong place. This is about what's happened over the course of this year when we decided to share a digital application with family lawyers around England and Wales. Now, the main thing, of course, that we have to consider, if we're going to build a digital application, we're going to put it out to family lawyers, what is the problem that we are attempting to solve? There's no point doing this just for academic reasons. So the proposition for Engage as an application is that the traditional method of engaging clients, prospective clients at the first meeting, involves us in getting all the information out of their heads and into our heads so we can synthesize it and provide some guidance and answers. So we do this in the time-honored fashion of bombarding our clients in a face-to-face interview, or more latterly a Zoom or Teams meeting, with dozens and dozens of questions. And time, of course, is the common enemy, because we often have clients, especially if they're in a paid first consultation, who will be clock watching and wondering, how quickly we're going to get to the answers that they want, because they're paying for this. And equally, as lawyers, we're also clock watching, aren't we? Because if we're in a free consultation and we're sitting there thinking, God, I only said I was going to provide 30 minutes free consultation, and now clocking on to 1 hour. We're watching the clock as well. So within this slightly strange first encounter, the beginning of the client journey, we're scribbling away, aren't we, the notes, all the information that we're given, because we have to protect ourselves against risk. And this is effectively, as far as I'm aware, most of the firms who've been using Engage this year, we were all doing scribbled handwritten notes, and I hope most of them were legible in case a colleague had to rely upon them if we fell under the number 13 bus. I'm not so sure, but it's a process that has really been unchanged for about 600 years since the time of scriveners. So we decided to try and build a digital application to tackle this information gathering. And what I need to share with you is there's no point just diving into building a bit of tech for the sake of it. You do need to have some design principles. You need to have some way of having a roadmap yourself, some values that need to guide you when you will have to make decisions about who you make the application available to later on down the road. So we aimed to engage at the clients, and we wanted to wrap it around a client experience rather than a legal process. So fundamentally, we wanted this to be free for clients, and it needs to be free because we know access to justice is a serious issue in this country. And by country, I mean England and Wales. That's the jurisdiction that Engage is deployed in. We know that litigants in person are clogging up the family courts. It's a fairly dire and horrible situation for them. And we know that with the withdrawal of public funding, that solicitors who used to act as early intervention agents and to signpost people away from the court process, largely that function has disappeared for us. And, according to the SRA and other sources, only 1 in 3 people who need family law advice will seek it. And I think, that's a fairly shocking statistic. Even worse for us when you consider that I think a lot of us on this webinar today are Resolution members who spend a lot of time in training on DR alternatives, but 45% of the public can't name an alternative to the court process. So our skill sets are going largely unused, or not certainly used as much as they could be. And just to top it all off, we know from the MOJ research and others that there are very low satisfaction rates with the dominant model of the free first consultation, and the satisfaction rates are not that much better, actually, when you look at a paid version of that consultation. So the other half of the equation, of course, is that if you build an application around clients, you've got to make it useful for the lawyers. And again, you're going to have some firm design principles before you start this. It's a process we actually started 10 years ago in the build and design and the iteration of Engage. So you have to be mindful of the situation for lawyers. 80% of us are in very small firms. So it means we don't have a lot of resources, we don't have a lot of money to chuck at technical solutions. Also, we want Engage to be plug and play to the extent that we know that email and PDF are free resources for both clients and for the public. And also in terms of us as lawyers, a lot of us are using Excel for matrimonial finance work. So we built Engage to plug in on top of existing resources. We absolutely didn't want any training required for staff members with Engage, hence the plug and play scenario. And we did not want any setup costs, because the last thing we want you to do, and believe me, I'm a business owner myself, so I do understand this, is we don't want you to have the cost and the hassle of messing around with your websites, with firewalls, requiring IT, in-house resource or external, expensive IT resource. And we knew that Engage had to do a couple of things. For lawyers, it had to save time, because that's the enemy, non-chargeable time. We had to try and cut that down. It has to reduce risk, and it must be deployable. You must be able to use it out of the box within 48 hours. Okay, so those are the principles that guided us in terms of Engage. So just to bring you up to speed now, and the reason that you're on the webinar this morning is you want to know what happened when family lawyers got their hands on a digital application earlier this year. So in January 2020, this year, we expected to just have 6 or 7 firms trialing Engage. COVID came along, lockdown happened, and we decided to throw open the doors to any resolution member who wanted it, and they did come on in their droves. And this is why you're here, because you would like to find out what happened. So the first thing I should do, and this is part of the learning that I want to share over the course of this year, the things that we've learned, is that you can have a digital application, which is great, and you are going to see this, believe me. I know you're very excited and you want to see what it looks like in practice, but we are getting there. But the first thing I've got to say to you is that you can have something new like a digital application, but it doesn't mean that you throw the baby out with the bathwater. There are some aspects of our process we have discovered work really well. So one of them is the first telephone call from a prospective client. So Engage works like this. You have a call from a prospective client, and our learning is that most people like to speak to somebody first, even if it's just for 10 minutes. And you can, on that phone call, position yourself as being human and empathetic and someone that they can trust. Our learning from the pilot firms who've been using Engage is that prospective clients love a free application. You get brownie points immediately, okay? So you get a phone call in as normal, you chat to that prospective client. All you need to do, and this is the height of your technical acumen, to be able to use Engage. Okay, remember the design principles of Engage has to be as simple as for any lawyer wanting to use it. All you need to do is to send that prospective client a link to the Engage platform. You can see here's a bit of spiel that we developed over time that we don't mind if pilot firms want to use this, but you simply email the link to that prospective client. They click on the link and they go off to Family Law Lab. So we let you get on with your day job, go and do some chargeable work, go and do some business development, okay? We will do the rest of the heavy lifting from this point. So, okay, this is the bit that you want to see. What does Engage look like to a client? Now, what you can see is a rather close-up view at the top of the first page of Engage, and I just wanted to point out a few things to you. So this is a digital application that's online. The clients we found after we had iterated Engage over a couple of years is that we had to give as much white space as possible. You can see this on the page in front of you. We discovered from feedback from clients that they needed space to metaphorically breathe in the experience online. So we had lots of white space. We even started to tone down the contrast in the font. You can see there's some grey font there. We worked on the shape of the font, taking off some of the kernels on that font. We've got a navigation menu on the left-hand side so that clients can jump around the form. And you'll notice right at the top, we've got a visual metaphor. We've got the progress bar we introduced in Engage after a couple of years. So the client can see that they're 7% into the journey or 30% or 90%. We discovered that that's really important to anchor them in the journey so that they have some element of control over this. And we are actually talking about allowing clients or prospective clients to exercise an agency in this. That's one of the important takeaways from having a digital application. So what I wanted to show you here is the massive difference between having an online document, an online experience like Engage, and a static document like a Word or PDF. So 50% of the firms who joined us this year on Engage was sending out static Word documents to get some information before a first consultation. So what I want to do here is just to show you the massive difference if you can have conditional logic driving the questionnaire. So in this case, you can see that the user is able to access contextual help. Again, we position them, we allow them to start exercising some control over their own journey and to be informed about the relationship type that they're in and some of the issues that they're going to have to deal with as they go forward. So here the user is looking at the different contextual helps to make sure they're on the right journey. You will notice as they click through the different relationship types that the questions at the bottom change. This is conditional logic. These are decision trees. Although there are thousands of variants on the questions that we ask in the back end of Engage, only those questions that are relevant will appear because they are driven by the relevance of the previous answers that are given. And you can see there as well, we will give acknowledgements, so thanking that person for selecting that particular relationship type, and just checking in with them that they've got the right one. So that's a massive difference between a static document that you cannot change and a conditional logic tree digital application like Engage. Okay, so what I wanted to show you on this screen is an important change for us in Engage after we'd had it up and running for a couple of years. We started to personalize it. So imagine that Mark Antony and Cleopatra have been resurrected. They're getting divorced, unfortunately for them. And Mark Antony's come to us for advice. What you can see on the screen is that we can address Mark Antony by name, because we've got that name, and we will use the name all the way through the digital journey. We will also give his spouse, Cleopatra, the courtesy of naming her. Let's call her Cleopatra all the way through. And if we have the children's names, we will address them by name. That personalization we've discovered on the feedback from the users is really, really important. And just another example here in this respect, conditional logic. If Mark Antony is going to mediation, we can dive down into that. We can get a little bit more detail. If he's not involved in mediation or the other dispute resolution options, then we won't ask questions about that. We can just keep him moving forward. I wanted to share this screen with you because I don't know about you. I used to do a lot of cohabitation work, and I used to do a fair bit of Talata and Inheritance Act work. When we are not dealing with a married couple, we don't have the prism of Section 25 MC8 to guide us. With cohabiting couples, it's more like a shaggy dog story, especially when it comes onto property rights. So in Engage, because we can pivot quite dramatically according to the relationship type, what you can see on the screen is a cohabiting prospective client. And we can guide the journey, we can provide some boundaries where we allow them in this particular screen to tell a bit of a story about what happened when they purchased this property. But you can see we pre-format it with some headings and we have italicized some guidance because we want to place some useful boundaries on the information they're going to give us so that it's reformatted to suit our lawyers' brains. So it's just a way in which we can sort of pivot quite quickly within a digital journey that you cannot in a static document like Word or a PDF. One bit of learning I wanted to share with you is that a lot of the lawyers on the pilot who joined us, one concern they would often raise is, look, Alan, there must be some questions that are so sensitive, that require answers that are so nuanced that you can't possibly ask them in a digital application. Well, our learning is that we haven't discovered a question that we can't ask yet. And believe me, we get lots of feedback, as I'll show you, from the users on what they think about the journey. So in this case, we've got Bonnie and Clyde. We've switched away from Mark Antony. Bonnie and Clyde are dealing with this, and Bonnie is being asked a rather difficult question about domestic abuse or coercive control. So what Bonnie can do is she can go into the contextual help to help her position what the response is here. We've got some live links there. It jumps off onto other sites if they want to get some guidance. But armed with that assistive framing, Bonnie can go back and think about very carefully how she wants to answer this question. And you will notice here, we're acknowledging it. Thank you for sharing this, Bonnie. We know it's difficult for clients, but what would you like us to do with this? We always try to provide jump-off points for us as lawyers in Engage to know whether this is background information that Bonnie wants us to be aware of, whether she precisely wishes us to take some action as soon as she comes in on the consultation. Another big learning point for us over the course of this year is we hadn't appreciated how many clients were effectively confined to only being able to access the internet or a digital application like Engage on a mobile device, often a phone. We think it's about 12% of the users over the course of this year only had access to a phone. So what we've done very recently, we just rebuilt Engage to be version 3, and we knew that we had to deal with this. So on the left-hand side, you can see the domestic abuse, coercive control, contextual help that was on the previous slide. That's what it looks like on a mobile phone in landscape when you turn it sideways. And on the right-hand side, there's another contextual help for the family home, and that's in portrait mode. So although it's only about 12% of the users, we must be inclusive. And that, again, coming back to the design principles of what we want to do with Engage, we want to carry everyone along on this journey. We don't want any barriers. So if you are confined to having a mobile phone in any event, we have to build this for you as well. Another bit of learning for you in the early months of this year when we showed Engage with different law firms, we found the feedback from the lawyers was that those clients who were dealing mainly with financial issues absolutely got the importance of Engage and embraced it, full-heartedly. There was a little bit more pushback from people who are just wanting to have advice about children. And when we drilled down to this with the lawyers and the feedback that they were getting, it's interesting. We need to do more work on this. We're finding that some of these prospective clients were saying, look, I just want my free interview. Okay, I don't want to go off online. And anyway, it's easy. It's just a yes or no. I only need 5 minutes from you to give me the advice. So of course, it makes our hearts sing. So we know it's much more complicated than that. So what we decided to do is to try and make Engage adapt to fit those people who may need holistic advice. They may need it about children and finances. But if they felt a little bit pressed and they felt that they really wanted to concentrate on children, we decided to give them a little bit of a departure here. So what the user can do on this one is just check in whether they should just concentrate on children issues, and we give them a bit of guidance. We give them some examples just to help them on whether they should focus on the kids or give us a whole submission. If they decide to just focus on the children, then we cut out large parts of the Engage journey. We do still concentrate on the family home and on income because that could touch upon welfare issues of children, but we've adapted Engage and we can do that in a way that a static document simply can't accommodate. Okay, one of the common points from the pilot firms that we had earlier in the year was just, comments like, Alan, this sounds great, digital application, but my clients can't be doing lots of typing. Well, there's very little typing, as you can see on the left-hand side. As lawyers, as specialists, we know, don't we, the questions that we need to ask. We know the likely answers. So what we do, because we know the sources of income, generally they're going to occur for a client, we make it really simple. We give them radio buttons and they can click away to the heart's content. They can add as many income sources as they want. And we will drill down with some additional questions depending upon the nature of the income source. On the right-hand side of your screen, you can see, and we've jumped back to Mark Anthony, by the way, here. Mark Anthony has already added 4 income sources for himself and for Cleopatra. A bit of learning for us as well is that we added in the facility for clients if they felt they'd made a mistake to go back and edit or delete, as you can see there, if Mark Anthony thinks he's got something wrong. The other thing that we realized that we had to do is not let the clients add up figures themselves. So Engage automatically does the heavy lifting, constantly flexes according to the figures that are being put in, and we will add everything up. We will subtract it. Okay, we don't want the clients doing that because they will make a mistake, and we don't want you doing it as a lawyer in the first consultation because you need to be concentrating on them and the guidance that you may be giving. Another bit I would like to share with you is we've realized that Engage, rather than being a fairly cold experience, and believe me, it's not, and that's the feedback that we get from the users, it's actually mimicking the human interaction in a face-to-face consultation. And I've got an example here. You will see on the left-hand side that we've come back to Mark Anthony and Cleopatra, that Mark Anthony is at step 10 of Engage, existing proceedings. Right at the beginning, we said to Mark Anthony, are there any family law proceedings you need to tell us about? And he said, yes. And what we do is we acknowledge it and we say, great, that's important. We will circle back to that, but not now. We want to know more about you. We want to know more about Cleopatra. Just as importantly, we want to know about the kids. You know, what's up with them? What's going on in their lives? But here's us circling back, and this is exactly what we do in a face-to-face traditional interview, where the client is telling a story, they're in full flow. We don't want to interrupt, but we're scribbling like mad in the margins of our notepad thinking, he's just told me really 3 really important things. I must circle back to them later when he's finished this part of the narrative. This is us circling back and engage. We haven't forgotten. You'll notice on the left-hand side, we've got some date fields. Whenever we get a date field, we will use that to automatically compute periods of time, as you will see. We don't need you spending time doing this. On the right-hand side of your screen, Mark Antony, we've drilled down a little bit. He's told us about financial remedy proceedings. And what we can do is we can find out about likely interveners. So in this case, we've got Octavian, third richest man in the Roman Empire. He's going to claim that Mark Antony and Cleopatra only borrowed the armies from Octavian. They're not going to fall into the marital request. Why do we need to know this level of detail before Mark Antony has even come in the door, before there's a client retainer? Because Octavian's a very rich man. He's got very expensive central London solicitors. He will come wading in to this case at month 3 or 4 as an intervener, and he's not going to give in. Okay, he neither forgives nor forgets. So we need to know that because it will impact on the cost estimate and the duration of time estimate. Better to have a realistic cost estimate for Mark Antony now, knowing there's going to be a lot of trouble with Octavian further up the road, than having to dramatically amend that a couple of months in. That wouldn't make for a happy client. So as Mark Antony goes through the engaged journey, and I'm only able to show you a fraction of this because of the time we've got this morning, but as Mark Antony goes through, we discovered it's really important to just give the headlines to the user within the online experience. So here is us giving the headlines to Mark Antony saying, by the way, this is what it's looking like for you. If he thinks that looks wrong, he can go back and amend it. As we know, this is often a revelation for clients the first time we've done this exercise, so it's often a bit surprising for them. We will do this in respect of income, as you can see there. We will tally it up in respect of capital. So another bit to share with you is that we've got percentage interests in there. We have that because we know that's a touch of delight for us as lawyers. It's really nice. We think about percentile interests on the assets, don't we? But we keep it in for the clients, the prospective clients. So Mark Antony can see this. The feedback we've had from the users and from the lawyers is that it's a really good idea to let the prospective clients start to think a little bit like us as lawyers. When they start seeing that we are talking about percentage shares on the assets, it makes a lot of sense for them when we get around to settlement discussions. So we keep it in there for the clients, not just for the lawyers. Okay, so we get to the end. And what we're effectively wanting to do is to make sure that Mark Antony is giving us all the information that we need. So we ask for this declaration. Within Engage, by the way, we do give a bit of a lecture on full and frank disclosure. We give it to every single user. We are only, as family specialists, going to be as good as the information that we're provided with by our clients. That's the simple truth. So we know when we designed Engage that we got all the data we could from the PII insurers, from the SRA claims, and from the legal ombudsman, and we built it in to Engage. So the 2 areas of risk for family lawyers are that we've given guidance or advice on an incorrect picture of the facts. So we've opened our mouths and we've said something, the client relies upon it, but we haven't done our due diligence. Well, we have an incontrovertible, time-stamped, date-stamped submission of what the client is telling us in case there's any arguments about this later, and the client can't change this. So we try and cover the factual element, but there's a second area of risk, and I'll come on to that in a second. It comes more from the ombudsman cases. But Mark Antony is told to declare and make sure that he's given us all the information that we need. This has to be the unvarnished truth so we can do our job. Mark Antony gets to the end of Engage and he presses submit. We automatically email out Mark Antony's submission. It's in a PDF. I'll show you an example of what that looks like in a moment. But it automatically gets carried out. So remember, at the very beginning of this journey, he phoned you up. You passed him across to Engage. You emailed out the link to him. You've got on with your lives, okay, hopefully productively. And in the meantime, in the background, while you've been sleeping or doing other chargeable work, Mark Antony has been doing his Engage submission. We automatically email it out to him. We automatically email it out to you, okay? So it's given to you on a platter. You'll notice it's personalized again. You'll see that my firm, Family Law Partners, which is the home of the innovation team that created Family Law Lab and Engage. It's got my logo there, but actually all of the law firms who use Engage, it would be your logo that appears there because it needs to be seen to become coming from you. Okay, this is what the Engage submission looks like. For Mark Anthony, in this case, he's got it encrypted. It's been emailed to him in an encrypted format for security. This is just one brief example. So the PDF that we reformat from all that data, we make sense of it. It's rewired for our lawyers' brains. We reformat it for him so he can see this. He gets exactly what we see. That's an important point, by the way, from the Ombudsman's cases about the client's understanding being on the same level as ours. So we're comparing apples with apples. There's often a breakdown in communication, what's in the lawyer's brain and what's in the client's. The Ombudsman gets very exercised about that and wants to see letters and all sorts of attendance notes. But here, Mark Anthony gets exactly what we get. You will notice that we keep in the percentile splits as well. That's a point of delight for us as lawyers. The client hasn't even walked into the office and you have this level of detail about the person who's going to walk in, but it's important for him as well to understand his own situation. So we break it down, we make sense of that for you. Now, what I'd like to show you is what we get as lawyers and that Mark Anthony or the other clients do not get. Because we have the data, we reformat it and we rewire it for our lawyers' brains. And again, this has been iterated over the years of using Engage, and it's just been iterated again in version 3 of Engage, only launched at the end of last week to all of the existing pilot firms. So you'll notice at the top of your screen, because we've got the dates of birth, we'll work out the ages, we will give you the headlines on whether the asset base is a significant one, or income. We will, on the top right-hand corner, do the conflict checks. None of the firms on the Engage pilot did a level of conflict check on the first call to this level of detail. I don't think any of us can. Clients are a bit uncomfortable on the first call being asked these questions, but they don't mind answering them. This is part of the learning as well in an online application if they trust it. So you can see our good friend Octavian appears there. We can do a conflict search straight away before Mark Anthony comes in, and we create a client retainer. A lot of firms are caught out, by the way, if you look at the SRA cases on conflicts only arising a couple of months in to the case. We will winkle it out now so you can just double check. The larger box in front of you, the one headed need to know this, all comes from the coalface of family law practice. This is very simply what the lawyers who have said to us, if I had a magic wand, this is what I'd like to know about this person if I only had 60 seconds before they walk in. So of course we reproduce the red flags if there's domestic abuse, if the client's asking us to take action, whether the children are at risk of harm. We will work out if they are in existing proceedings. We will tell you if there's a hearing coming up. That's really important. Some of the teams using Engage are larger. They have gatekeeping roles, and they will use this to work out whether the case goes to someone specialising more on the children's side or more on financial remedy. It may be the case, of course, that the family team doesn't handle TOLATA or Inheritance Act, in which case they can signpost it within the firm. They may even need to signpost it outside of the firm if they don't feel that it's their bag when they see this heads up. But better to do that now and to control that rather than create a client retainer and then perhaps become a bit out of your depth, or in some cases take on a case when you shouldn't have. We all need to think about capacity. Someone may be off ill, we may be about to go on leave. It's really helpful to have this heads up and work out the level of input that we would need on this client case if we took it on. Now, one thing I wanted to share with you right at the bottom of your screen, if you can see that box, it's in yellow or amber. It says what Mark Anthony would like you to know. So I mentioned before 2 risk areas. One is that we open our mouths and give what the client understands to be guidance or advice on the basis of an incorrect understanding of the facts. And we think we deal with that and Engage. The other one is that we've done our job right, we've done our due diligence, we've got the facts, we've done the discovery and the disclosure, but somehow we fail to meet the expectations of the client. So we try and deal with this, and this often comes from the Ombudsman's cases. In Engage, what we do is we say, Mark Anthony, you've been really patient. It's been a great investment of your time, though, because your family law specialist will be able to focus on you when you come to the consultation. But before you go, what's the one thing that we need to hear from you above all else, above all the white noise of everything else that's going on in your case? What's the one thing you hope to achieve, or what's the one thing you really want to avoid in the assistance we're going to give you? And Mark Antony, when he sees that question, he can click on the contextual help, and we have real life, but anonymous, of course, but real life submissions from earlier clients. And I'll give you one from a lady who completed Engage about 3 years ago. And her answer to this question was, the one thing I need you to know is that after 35 years of marriage, me and my husband are separating. We're going to get divorced. It's deeply, deeply painful for us. The one thing you need to know is that he is the best human being I've ever had in my life. And if you attempt to crucify him in these proceedings, if you are disrespectful to him for one instant, I will disinstruct you in 5 seconds. That's what she needed to know. It wasn't about who got the ISAs, who got the home in France. That's the one thing we needed to keep at the very front of our minds at all points. And that's the first thing, if we're really savvy, that we will reflect back to her in the first couple of minutes of a consultation. And the first thing that will be in the paragraph of our written communication to her, to make her know that we've got her back, we understand where she's coming from, and that we can deal with that appropriately. So that's how we try to deal with that expectation point that often comes up in the Ombudsman's cases. Okay. We don't just give you an Engage submission. Because we've got the data, we can ping that off into an automated asset schedule. We measure lots of things in Engage, and we can tell you that we know it's about an hour and a half for even an experienced solicitor on finance to create a asset schedule in Excel from a template. An hour and a half, that's a lot of faffing. It takes us 3 seconds, so you might as well have this. It's something we hand off to you. That's just an example of one of the tabs where we reproduce some of the biographical information. We will reformat all the information for you. If there are 10 properties, you'll get 10 properties. If there are no properties, the whole spreadsheet shrinks. It reformats itself automatically. We do all the adding up. Okay, we don't want you doing that. We had a bit of learning, which is that in some cases, which have led to claims, lawyers, whether using Excel, they may have added later on within the disclosure process, a new asset has come to light. They add it in, they've got the little asset spreadsheet, but they've forgotten that the cell reference is incorrect. It doesn't get added in properly. And we're looking at settlement options where a significant asset may have been missed out. So we have added a macro where you can just automatically create that. The spreadsheet will know it needs to add a cell reference, and it will double check that it's all being added up into the right places. So we try to control that aspect of risk for you. Okay, now another bit of learning. There's no point putting all this time into building a digital application, even if it's got fantastic utility for lawyers, unless the clients like it. We ask every single user to give us 60 seconds feedback in Engage. We have a 67% completion rate, which is astonishing for a survey on a digital application. It's normally between 7 and 10%. We get positive, highly positive, satisfactory. Clients do like it. I've headed this, my clients won't like it. That's what I used to get a lot in the early years of Engage from usually senior partners who'd say, my clients won't like it. I'd say, how do you even know if you don't give them the option? I'm afraid clients do like it, and that's one of the things I just wanted to blow out of the water. The clients are telling us that they're absolutely fine with it. Another bit of learning for you is that Engage as a submission has utility beyond the first consultation. We thought we were only designing it for that first crucial consultation. We found that the lawyers are looking at it almost on a daily basis right throughout the lifetime of a case. So realize they're using it just to do a sanity check on the facts. In some cases, they don't need to go through a voluminous file because the only thing they haven't got from the pension sharing annex is the spouse's national insurance number. We collect that. They can do sanity checks of the court on the hop if it's a junior lawyer dealing with an important client and the partner's out of the office or in court and they've got to call that client back. They can quickly go to Engage, get the names of the kids and just have a quick check on the client's expectations. We haven't got time this morning, but there are some specific examples that we've got from the lawyers on how they have used Engage to deal with client pushback, the expectation point, and being able to do that very intelligently and sort of head off some difficulty with the clients when they've been able to just say, you told me this is what you wanted to do. I've adhered to that all the way through. I don't know who's whispering in your ear, but you need to tell me now if your clients, if your instructions have changed. So some of the lawyers have said they've been able to handle that really well, having that expectation piece, what Mark Antony most wanted to achieve. Again, we've discovered, firms are using Engage really flexibly. So we thought it was all about having the first consultation, but some firms, if the client's a bit wobbly on the phone, they're saying, look, just you've started Engage, just say what you've got, come in and see us. If it's urgent, we can deal with it. But you know what, if it's urgent, we may miss something. So go back afterwards, complete the Engage submission. At least then we've got a way of checking that we reviewed everything, because if we need to amend our advice, we can. I've also observed, really interestingly, over the course of this year, some flex in the business models. So some of the pilot firms on Engage are now insisting on an Engage submission before they will give a free consultation, starting to value their time a little bit more, even in areas where the free consultation is the dominant economic model, just perhaps becoming a little bit more confident about the value they can offer. The firms who were doing free consultations are now boundarying it really firmly and saying it's 20 minutes max, because we can do a lot of work in 20 minutes if you give us the Engage submission. We don't need to go over. So they're no longer, the mission creep of 45 minutes, an hour and 10 minutes. That's not happening. Some firms, interestingly, are abandoning the free consultation model, and with Engage, they're now giving a fixed fee because they think they can offer value to the clients. Some of the firms who are already using fixed fees are now increasing, interestingly, the extent of the fixed fee when they're able to use Engage and the client agrees to use it. Also, I've discovered with a handful of the firms, they're using Engage as a filter. The clients will phone you up and that they're really going around the town and trying to get 5 or 6 free consultations and stitch it all together. That's a Frankenstein's monster. We know that's going to end badly for them. But just using a bit of a filter for those people who are really genuine about wanting to get some assistance and guidance. Because if the clients are saying, no, I just want my free interview, I can't be bothered going to do that. Well, the lawyer's now pushing back a little bit and saying, well, your time's really important, but so's ours. And you're not being charged for Engage, it's free. So, if you can meet us halfway, we will meet you. And also we're getting good feedback about firms who are able to just make more informed decisions about whether to accept that client. And interestingly, if they do decide to refer it out of the firm, and it might be to a valued network of other solicitors, how nice to be able to tie a ribbon, if the client agrees, the prospective client agrees, tie a ribbon around the instructions and be able to forward the Engage submission to your valued referrer relationship. We're getting some feedback that's quite a valued aspect of Engage. And of course, it's nice for that prospective client because they've not been charged and they don't have to repeat themselves. They're being passed to another lawyer, but they don't have to go through the whole process of completing Engage or talking to someone again. Okay, I'm getting towards the end of the webinar itself, and I'd love to deal with some questions if there are any. I just want to share one thing. You can have a technical application, but it's about the behaviors of us as humans, about individuals and legal teams. The successful teams using Engage, the ones who've really flown, they always mention it on the first phone call straight away. And we did discover that some lawyers were cherry picking whether to mention Engage on the phone. And when we sort of challenged it a little bit, we found that it was because some of the lawyers were saying things like, oh, I thought that my client wouldn't be comfortable with technology. I don't know how you would make that judgment. And I think there's a little bit of projection going on there from the lawyers perhaps being a bit uncomfortable with technology. I can say that we're amongst friends here. Okay, let's just acknowledge it. So the firms are really, really flying with Engage, always mention it on the phone. They do not make an assumption about whether the client would like it or not. You give the client the option. They always make sure that the whole team knows about Engage. Anyone who will answer the phone, a receptionist who may not even be in the department, everyone is on the same page, and they always follow up with a link to Engage. Interestingly, a fair few of the firms on Engage didn't follow up a prospective client call with an email, which I found interesting myself, but you always follow up. So there are some behaviors, it's about embedding it in the firm, but we can see some best practice emerging, and we would like to share with the firms who come on board. Now, I know that we're all lawyers. We know we need to keep focused on time. Some of you may be business owners as well. Because of all the metrics that we've got on using Engage over the years, we put them into a calculator. If you want to go to Family Law Lab, which is where we live, and you can Google it and it will take you there, you can enter this. And I would recommend that you do it, because if you do the calculation of how much time you can save and the value of that time to you, and if you put in your email address, and by the way, I don't use that for marketing, I haven't got the time, seriously. If you email it yourself, you will get a PDF which will give you a detailed breakdown of how we've worked out the metrics. So I would invite you to go and use that. You may as well learn from what we've learned. So as I come towards the end, I think the benefits of Engage really crystallize around these points. And remember, this all comes back to the design principles of why we did this. There is a bit about access to justice. Engage must be free. I fundamentally disagree with any offering that says a client can only use it if they can pay £100. It doesn't matter if it's £50. It doesn't matter if it's £5. It will disenfranchise somebody. If we're going to get serious about access to justice, we need to make it free. And we need to make it really free for clients to instruct us. There's a risk piece on this. With consistent question flows through Engage, we have consistency and we manage the risk, especially if they're more junior lawyers, in some cases paralegals doing the first consultations. Travellers, by the way, PII firm who came across Engage, they called it a unique risk management tool. So I can tell you that in my own firm, Family Law Partners, we've twice had our renewal quote reduced when they saw Engage. Conversions, it's really important about building the client relationship. We call this putting down the pen and concentrating on the body language, what your client's telling you, really listening to them rather than them seeing just the top of your head because you're busy scribbling a note. You've got the information from Engage, just concentrate on them. We found that it's been particularly helpful, and perhaps one of the reasons it's taken off because of remote hearings. There's a big cognitive load for us as lawyers and for clients in trying to communicate if the connection's a little bit patchy. So don't waste your time on a Zoom asking them lots of questions, have that beforehand, and then concentrate on them in the virtual meeting. There's a time piece about maximizing that. We've measured this, believe me, over the years. It's about an hour to do a really granular attendance note. You don't need it if you've got Engage. So cut out an hour, okay? None of us like doing that sort of stuff. It's an hour and a half to do an asset schedule. Just get rid of it. Take 3 seconds instead. And the end bit, I suppose, is about valuing the day job, what we want to do. Our clients see no value in paying us to be data collectors and scribbling and taking information like this. So why don't we connect up the value bit? For us, I enjoy giving advice, I enjoy giving guidance. I do not enjoy the groundhog day of the same questions again and again, month after month, year after year. I'll let Engage do the heavy lifting and I'll get around to the guidance and advice. I enjoy it. It's what the clients really want to pay us for. Okay, you've been fantastic. Thank you very much for listening. I guess that if any of you would like to come onto the Engage platform, and you're more than welcome, all you need to do is probably to navigate to the Family Law Lab website. There's a simple contact form there. Drop us a line and we will take it from there. I should let you know, of course, that Resolution, who have assisted us and are co-hosting the webinar today, they have negotiated with us to give priority access to Resolution members, which is as good a reason for joining Resolution if you're not a member as I can think of, just to get your hands on the software. So that is the end of the webinar. I except for taking some questions, which I hope that we will have. So forgive me if I stop the share, and forgive me because you have to look at my face for this. I can see that Christopher Bowen has come to my rescue. Thank you. Chris, who's raised a question, can you use the tool on an existing case? You can. Fantastic question, Chris. On some of the feedback we've had from the lawyers over the course of this year, I was speaking to, I would love to name some of the firms. I haven't specifically asked for permission from this, so I'd better keep it anonymous. I was speaking to a great lawyer I get on really well with, and she shared with me that she had had a case that before she came on the Engage platform, she'd had a case for 2 years. And this is with a female client who was having real difficulty allowing the lawyer to progress the case. So as an experiment, she sent her the Engage submission, even though she'd been into the case for 2 years. And the client filled it out, it came back, and the lawyer said to me, she nearly dropped off her seat. On the expectation question, what's the one thing that the lawyer needed to know? The client had put, I'm still in love with my husband. Full stop. The lawyer phoned her up and said, I've been dealing with you for 2 years. I've not been able to progress the case. Why can you tell me that? And the client said, I don't know. I could say it on the form, but I couldn't say it to you. I'm sorry. That's why you can't progress it. I'm still in love with him. I don't want the relationship to end. It's really sad, but we've discovered that some of the other firms are also using it in that way. And there's a flexibility about Engage. I admit in the early years, going back 10 years when we designed this, I thought it was all about a shelf life that stopped at the point that we had the consultation. And I was wrong. It's being used in lots of imaginative ways beyond the point of the first consultation. If you need to do urgent work, you can still get your client to do it after the consultation. And in the case, in the example I've just given you, where you may be involved in a case you're going forward and maybe you don't feel you're progressing it very well, client's not giving you the information, you could just send it out to them perhaps as a refresh exercise, especially perhaps in cases where they're unbundled, you haven't heard from them for a while. I think it's a really good way to just start again with a clean slate. So it's a great question. Thank you, Chris. Somebody has asked me, what if the client only partially completes his or her submission? A good question. So it raises a number of operational issues and also GDPR. So from a GDPR point of view, we cannot submit. We can't submit it until they get to the end and give a specific consent. So it won't come through to you as a lawyer. So that's from the GDPR point of view and informed consent. But from an operational point of view, if a client has only partially completed it, what normally happens on our feedback is they would get in touch with the lawyers and they would say, for instance, there could be all sorts of reasons like, I don't want to continue anymore. It may be, I've been made a settlement offer. Do I still need to fill out engagement? Yes, absolutely, you do. There can be all sorts of reasons. It might be they're feeling a little bit wobbly. They've started it, it's created some feelings in them. They may just want that reassurance of a quick call with the lawyer. So if they only partially complete it, it sits there. It can't be submitted until they're ready, but very often they will let the lawyer know if they're not ready to proceed with it, and the lawyer can just find out what's happening. But most of the lawyers normally persuade them to just, in their own time when they're ready, go and complete it. It may be after they've referred that particular person to a family consultant. Perhaps some counselling needs to be done first, but they can go back to engage later. It's fine. They can do it in their own time. I've got another question here. Following on from the first question, that's about can you use the tool on an existing case? Following on from the first question, could I fill in the blanks myself on an existing case if I wanted to have a complete picture, but all the info was spread about in my file? Okay. I'm not quite sure I understand the question, to be honest with you. I might be being a bit thick. I'm not sure whether you are talking about being able to do a test, a demo of that, or whether you are saying, could you try and do it yourself on an existing case? It's all about the user, actually. We want to get away from spending non-chargeable time ourselves as lawyers. We put all of that onto the user, the prospective client. And it's a good bargain as far as I'm concerned. They're not being charged. And they're not going to spend a lot of time being bombarded with questions by us in a Zoom or a face-to-face if we get back to that. So it's all about the client journey, actually. And I think it's really important that they do it. They answer the questions rather than there being an intermediary like us. I hope I've understood the question, and apologies if I haven't. Another question is, how much is it? And someone else has also echoed that. Anonymous attendees, who's asking me this question? Well, I'll give you the same answer anyway. I don't care who you are. We don't charge for Engage, and we haven't been charging for it so far. Remember the design principles of Engage and why we started this. And for me, it's quite personal. I used to do a lot of public funding the first 15 years of my professional career, a lot of that in court proceedings. So I don't do legal aid anymore. Perhaps it's a guilty conscience, but I started building Engage because I wanted to make it easier for people to instruct us. And we know the cost and process are barriers with the way we have analog processes at the moment. So we decided not to charge Engage. We wanted to get more learning as well. We wanted to see, I know, because Engage has been used with clients on the southeast of England for 7 years. I know it works. I can put values on the time that's saved. I know how clients feel about it. I know how users feel about it. Sharing it in a pilot was a way to see, just to test some assumptions. Would it work outside the southeast of England? Would it work in South Shields, in Penzance, in Caerphilly? Is there something about the southeast demographic that means it would only work there and not elsewhere? We've discovered now over the course of the year, it doesn't matter about the geography. Family law clients are family law clients. The lawyers are all pretty much the same. So we didn't want to impose a cost because we wanted to get the learning as well, and there's a bit of access to justice piece. As we go forward, we've got quite a lot of firms now using Engage. I have a lot of firms on the waiting list wanting to come on board. So my honest answer to this is that in likelihood, at the moment, I've only got a small innovation team who are shouldering the burden of Engage. It is costing us money on a monthly basis, never mind the capital to do the rebuilds. It's likely that we do get many more firms coming on. I will have to say to people, guys, you will need to perhaps make a monthly subscription to this to keep it going if you see the value, but no one is tied in to the heads of agreement if they come onto the Engage platform. You can walk away in 24 hours. Okay, and that's part of the bargain with you. All I want is feedback. But if I do have to ask for some cost, I will do that on the basis that we're all getting some value from it. And if we do get some income in, it also means that we have some development funds, because believe me, Engage, what you're looking at now, we were here 7 years ago. We've worked on other prototypes at Family Law Lab. We would love to take the dust sheets off them and to share them with you and to share them with the public. We do need a little bit of cash to be able to do that. So not being charged at the moment, but it's very likely that I would need to have a discussion with the firms who still want to use it about making some contribution, because I think I would need to recruit another couple of bods just to help us to maintain the platform. Okay, so I hope that was a reasonable answer to you. I can't see any other questions coming up. I'm going to just give it a few seconds to see if anything does come up. But just to reiterate the point I mentioned before, which is on the heads of agreement. I know that as I'm a business owner as well, so I do get this. You know, some firms are a little bit nervous about coming onto a platform like this. What makes it easy now is that you can see that there are dozens and dozens of firms who've been using it. And we know there's not a GDPR issue. We now can see the success of embedding it in teams. It is about human behaviors, not just the technology. We can now start to measure how teams can be really effective on saving time, importantly, but also reducing risk, especially if you're delegating down a lot of the free consultations or the fixed fee consultations to more junior member of staff or paralegals. So we can see how this is all making sense. But I'm absolutely being really candid with you in the heads of agreement that all the pilot firms, and I'm not sure if any of the pilot firms are actually in on the seminar this morning, but they could vouch for this, is under the heads of agreement. I'm not tying anyone in. So if in the future we do ask for some cost and we do have a costing regime, you can walk away. You're not tied in. All I ask for is the courtesy of giving me at least 7 days notice that you don't want to use the platform anymore, so I can just tidy up the back end of the server. But that's the extent of the bargain that we have at the moment. And I think that so far for me, it's been a fascinating year, very busy year, but fascinating just seeing a digital application being used in the wild and just seeing the flexible and some imaginative ways in which the lawyers are starting to use it as well that I hadn't anticipated. And that's great learning for us. Because as I showed you on that amendment to the children question, we learn from this and we constantly adapt Engage. And all of the stuff that makes Engage strong, in my view, is the fact that we've built it up from the practitioner level upwards, rather than parachuting it down. And we test, and we test, and we test. All our assumptions are checked and tested. We make sure it's working. We make sure it gives value for the clients on the feedback, and we make sure it gives value for the lawyers overall. So it's been a great time for me, actually, personally. And I've made a lot of friends, actually, amongst the pilot group. Okay. I haven't seen any more questions appear, so I'm going to take that as the fact that 3 minutes to noon that I can be released. Thank you very much for your time. If you do want to come on board, just navigate to the Family Law Lab website, ping your details on there, and we will be in touch. Okay. Thank you very much. Have a fantastic day.